driven crime number 31 of 2024 has driven the petitioner to this court in the subject petition. The facts relating to the registration of the crime is generation of disproportionate assets to the known source of income. The Lokayukta is said to have drawn a preliminary inquiry report pursuant to which an order under section 17 of the Prevention of Corruption Act permitting registration of the crime, a search then conducted, and the search yielding certain properties which were allegedly disproportionate to the known source of income. The learned senior counsel Sandesh Chowta, appearing for the petitioner, submits that the issue in the list stands completely answered by the judgments rendered in the cases of so and so Nirankar Nath Pandey, Shankare Gowda and Satish Babu. Therefore submits that the preliminary inquiry, though conducted in the case at hand, it cannot be a preliminary inquiry in the eye of law. It is only an eyewash of a preliminary inquiry that is conducted. Therefore, this court must hold that the preliminary inquiry is not even conducted in the case at hand and would straightaway fall within the parameters of the law laid down by the coordinate bench in the case of Satish Babu or Shankare Gowda or Nirankar Nath Pandey as held by the apex court. Per contra, the learned counsel B. Latif, appearing for the petitioner, submits that preliminary inquiry was conducted, or during the investigation several skeleton has come out of the cupboard. The learned counsel B. Latif submits that a perusal at the APR annual property returns which was filed before the state was perused. In the said annual property return, what was declared was 1,650 grams of gold jewelry. When the search was conducted, the search yielded not 1,650 grams of gold jewelry, but about 4 kilos. Apart from the gold of 4 kilos, it transpires that about 900 grams of diamond is also found in the house of the petitioner. All put together, the learned counsel B. Latif would submit that the value of the value of the difference between the APR and the search conducted is close to 3 crores. Insofar as the cash is concerned for the relevant year, what was declared in the APR was 15,28,000, and when the search was conducted, the cash found was 25 lakhs. 25 lakhs in the house of the petitioner. He would submit that these are matters of trial and this court should not interdict the proceedings. As assets that are assets beyond the known source of income is clearly found in the case at hand. The learned senior counsel would join issue in contending that the gold or diamond that was found in the house the search was conducted at the time of the engagement ceremony of the daughter. Therefore, jewelry or gold would obviously be in the house. It need not be that the petitioners only, it could be the relatives as well. The learned counsel B. Latif submits to cap it all. There are properties registered in someone else's name, 4 apartments.
4 apartments.
There are 4 apartments found in someone else's name, which is part of the source report itself. The source report, the Lokayukta's prima facie concluded that it is Benami on the score that the rent of those 4 apartments are received by the daughters of the petitioner. With this being the case, the learned counsel B. Latif submits that the petition should not be entertained. I have given my anxious concern, so heard reserved. Yes.